Welcome to EUPrivacyForAll Session43 on GDPR, Supervisory Authority, Article 46. European Parliament suggestion to have Member States notifying the Commission on those provisions of its law adopted to designate a supervisory authority was retained. EU Council added the wording independent to mention that public authorities will remain fully independent and proposed the deletion of any reference to fundamental rights, which was not retained. Each supervisory authority, as suggested by EU Council, shall also contribute to the consistent application of this regulation. It shall cooperate with each other and the Commission. The final draft of Article 46 lays down that each Member State shall provide one or more independent public authorities in order to protect the fundamental rights and freedoms of natural persons and to facilitate the free flow of data within EU. It also lays down that each supervisory authority shall contribute to the consistent application of the regulation and cooperate with each other and the Commission. Where a Member State has more than one supervisory authority, it shall designate the supervisory authorities that will represent those authorities in the European Data Protection Board. Finally, each Member State shall notify to the Commission the provision of its law adopted pursuant to this chapter, and without delay inform the Commission about any subsequent amendment. The obligation to establish a supervisory authority in each Member State is also laid down in Residual 92. With more than 300 references to supervisory authorities, the GDPR will be further detailed in dedicated sessions. But let's notice that Recital 27 on the main establishment lays down that the competent lead supervisory authority should remain the one of the Member State where the controller has its main establishment. In case a same company would also act as a processor, the supervisory authority of the processor main establishment will be acting as an authority concerned and will participate to the cooperation, but will not be the lead one. Also, the representative of the company might be addressed by any supervisory authority. And concerning data protection impact assessment, the Recital 66A or 74 stress the fact that the controller that cannot mitigate the risks identified in a DPIA will have to consult the supervisory authority prior to the processing. Currently, the directive lays down that there might be one or more public authorities acting in each Member State, acting also with complete independence. They shall be consulted when drawing up administrative measures or regulation and be endowed with investigative powers, effective powers of intervention, but also the power to engage in legal proceedings, and each supervisory authority shall hear claims provided by persons concerned that will be informed of the outcome of the claim. It shall also draw up a report on its activities at regular intervals, and it will be made public. Each supervisory authority is competent, whatever the national law applicable to the processing in question, to exercise on the territory of its own Member State. It will cooperate with any other authority to the extent necessary for the performance of their duties, notably regarding the exchange of useful information. Finally, a professional secrecy obligation is identified for the members of this supervisory authority. What should accountable data controllers and processors get prepared for? First, keeping in mind that there might be one or more independent public authorities acting in each Member State to frame data protection regulation. They should pay attention to a set of regulation documentations that would come from diverse stakeholders, such as the regulating authorities, their EU counterparts, but also courts like EUCG in Luxembourg, the court in Strasbourg, and national courts that will define the way to better protect the fundamental rights and freedoms of EU citizens relating to the processing of their personal data. Controllers and processors shall also bear in mind that those national authorities will cooperate with each other nationally at EU level, but also with EU Commission. They should identify their lead supervisory authority, and it will be further detailed in the session regarding main establishment. And the company, if acting both as a controller and as a processor, should consider that the supervisory authority in charge will be the lead DPA of the controllers, and that the lead DPA of the processor, if different, be concerned, but only participate to the cooperation procedure. What will be interesting now is to know how the set of cooperation mechanisms to be settled between supervisory authorities will concretely work.